Good morning to all of you. Welcome to Legal Matters by Sai Baba Sankara. Supreme Court has to make a note of the clogging of the courts are clogging with the bail petitions, particularly under Bihar Excise and Prohibition Act Amendment 2018, particularly Amendment. 16 judges, they have to deal with the bail petitions. Of course, in certain circumstances, the high courts are refusing bail, and now the pressure is going to Supreme Court also. Now, Supreme Court has to be concerned about the so-called pendency of the bail petitions and pressure of the bail petitions from the Bihar courts. Why these things are happening? So this is an intricate subject, right? While disposing the bail petition of Monu Kumar, M-O-N-U, Monu Kumar and others versus State of Bihar in special leave petition number 1426 by 2022. Right, Supreme Court sought the response from Bihar state as to what they thought before framing the amendment or before enacting the amendment, and did they not consider about the manpower and the physical strength of the judiciary. All these things they have to consider. Whether they considered or not, all these things the state has to tell the Supreme Court. Please remember. So Justice Sanjay Kishan Kaul and M.M. Sundaresh asked the state to analyze, right, or as to what has taken place before the amendment was brought into existence. So what happened means, what are the discussions? There is no discussions are not necessary. Only thing is regarding the infrastructure of the court and also manpower required to deal with the litigation, so which would arise from statute. సో ఇలాంటి అమెండ్మెంట్ వచ్చేటప్పుడు మొదట్లో స్టేట్ కూడా ఆలోచించుకోవాలి. ఒక్కసారి మనం బెయిలబుల్ నాన్ బెయిలబుల్ చేస్తే విపరీతంగా పిటిషన్స్ వస్తాయి, విపరీతంగా అరెస్ట్ అవుతారు. మరి అప్పుడు ఆ పిటిషన్స్ డీల్ చేయడానికి ఎన్ని కోర్టులు కావాలి, ఎంత మ్యాన్ పవర్ కావాలి, ఎంత మీరు ఆలోచించారా లేదా అనేటువంటిది the Supreme Court has asked the State of Bihar to give a response on this particular topic. And now the point before the court is, number one, terrible pendency regarding the anticipatory bail applications, and secondly, pressure, terrible number of filing of the cases, filing of the petitions under section maybe 438, 439, 437, regular bail like that. Sorry, not regular bail, already arrest in tarvata endukante they are non-bailable offences. And secondly, the court also asked the state to consider about plea bargaining, 235A, plea bargaining, whether it is any possibility of plea bargaining. That means the sentence will be lessened. Suppose you all know that plea bargaining, suppose if the man admits the offense, if the punishment is for 2 years, he will be getting only 1 year punishment. So please look into that chance also. The state is asked by the Supreme Court. Because presently the number of cases or petitions are pending heavily in the high courts, and on one occasion 16 judges, they have to postpone the other matters and they have to deal with the bail petitions. And high court normally, actually this Monu Kumar case also came as the court refused. High court refused to or dismiss the bail petition of Monu Kumar. Sometimes they are also passing the buck to the Supreme Court. So please remember, they actually literally, the Supreme Court and the High Court, they are being crowded by the bail petitions, right? So 16 judges, they have to listen to the bail petitions, and they have to postpone the other matters because these are important. So please remember, now court, then Justice V.R. Krishna here. So bail is a right and jail is an exception. So therefore Supreme Court says denial of bail would result in crowding of petitions of this type, right? So now let us discuss what is section 16 of the so-called Bihar Amendment Act, Bihar Prohibition Excise Amendment Act. Presently, Section 16 says, please remember, this amendment says it prohibits the manufacture, then storage, then distribution, then transportation, business, sale, purchase, and lastly possession. Possession and consumption of the so-called any intoxicant or liquor is punishable under this amendment. So whenever any person is caught in possession, arrested, caught consuming, arrested, caught doing business, arrested. So everything is made a non-bailable offence, as a result of which so many people are coming for bail petitions. Anyway, so this is an occasion, alarming situation where the courts are flooded with only bail petitions regarding the Bihar Prohibition Excise Amendment Act 2018. So before that, so please remember, these people, the state has to think over, suppose when we make it a non-bailable, how many cases has come and what are the infrastructure we have to provide for the court, and how many special courts have to be established in this connection. All these things they have to discuss. So whether you have done that exercise or not, this is the question given to the Bihar State by the Honorable Supreme Court of India. Let us see what will happen, what will be the response and other things, right? So anyway, overcrowding of jails. Then you have to remember Rudolph Shaw case. Then plea bargaining, CRPC. Please refer to section 235A or something. A, B, C, D, E, F, so many sections will be there. And right to speedy trial, anticipatory bail or regular bail, 437, 438, 439 CRPC. Please refer to all these sections and definitely your legal knowledge will improve. Thank you very much.